Hi, everyone. I'm Joseph here. Thanks for joining in today's live session. We're going to do two parts to today's show. Oh, that's the button. Oh, no button. Very good. All right. Yeah, we're going to do two parts. The first part, we're going to talk about immigration judges today. Now, during the first part where we talk about immigration judges and what it's like to go through the immigration court and a lot of discussion about the due process nature of being in immigration court, feel free to ask questions. Sometimes Galen will ask questions during the discussion on this news topic, or he usually saves it afterwards. So we talk about and answer any of your questions regarding immigration. And then after the Q&A session, I'll talk about a live filming of a news story. And it is one where this lady was about to get her case terminated, sent to immigration court, deported. She got a notice of intent to deny, all because she presented one wrong document according to a USCIS officer, right? She got married in the US, she filed for adjustment. Under all normal circumstances, she would have gotten a green card, but she was forced to apply for a waiver. We had to do it within 1 month. I want to walk you through everything that happened so you can see exactly what's kind of going on the ground with USCIS these days, especially for marriage-based immigration cases. And then again, I'll answer more questions at the end of that live new recording show. So today's news story is about immigration judges. There's so much to talk about here because you might think immigration judges is a judge. It has the due process power. And if you go through the immigration court system, you had your due process right. And if you're rejected, you send home, deported, it's all fair. That's a lot of times the end discussion when I hear a lot of these debates. Well, they got their due process because they went through the immigration judge court. I would like to kind of set the scene so you kind of know exactly what an immigration judge does. And a lot of people who are in the process, and that's the benefit of talking about these news segments. You know, we're talking on the ground, not just the philosophical debate about whether or not immigration judges should become an Article 3 court, which I don't think they ever will. But we're talking about what does that mean to people who are in the process, whether they filed their case with immigration court, whether they're stuck in immigration court, whether they need to get out of immigration court. What is that like, right? Because again, we have a lot of these cases in this process. Should you file a 42B? Should you file a 42A, cancellation and removal? Should you try to open your case and terminate it so you can adjust your status? What is that like? What are you facing? It's not just about filling forms, because for a lot of these clients who are about to be sent to immigration court, whether they got picked up by ICE or whether they might be picked up by ICE or whether they are with USCIS to be sent to ICE, to be sent to immigration court later on, they need to know the context. So first, what is it like? Well, in all of the US, there's only about 600, 700 immigration judges now, and that's already a record number. Sure, you're seeing some immigrants being fired, but I assure you, they will be rehired back. And when I say hire, I'm not saying, nominated for a lifetime position like a normal judge you would think of at the state level, at the federal level. You think family judges, you think court judges, you think federal litigation courts, you see Supreme Court. Those are all Article 3 judges that are appointed for life, that are part of the judicial system. But for immigration judges, they're not. They get chosen and hired on by the Attorney General, who is appointed by the President. They are directly part of the executive branch. So whatever the President's agenda for the nation regarding immigration, they will select an Attorney General who shares that belief, generally speaking, and all other beliefs. And then the Attorney General selects the immigration judges. Right now, there's over 3 million backlog cases and only a couple hundred people. And when I say people, I'm talking about immigration judges. But what are the qualifications of these immigration judges? I know there are a lot of people from the left that kind of make fun of these immigration judges, saying that they're not true judges. That's not fair. To be selected to even be hired on by the agency, by EOIR, to be an immigration judge is rigorous. You go through the background check, which could sometimes take years. The hire process is slow. You'll be scrutinized by the EOIR office. You're supposed to know the court proceedings. You're supposed to know your stuff. That doesn't necessarily mean you need to know immigration law, which is very shocking to a lot of people. And the reason for that is actually just pure practicality. It's just the background check is so tough, the qualifications is so high to be an immigration judge that if you also require them to know immigration law, let alone to be a certified immigration law specialist, you probably won't be able to hire anyone. So it's just not fair to say, oh, immigration judge requires to know immigration law. Obviously, it's a plus, right? In their hiring manual, it's like it's a plus if you know immigration law, if you handle some. And immigration law is extremely complex. There's business immigration, EB-1 through EB-5. There's family immigration law, and there's deportation and asylum law, right? They're all very different. And many immigration practitioners who just know one area don't know much about the other areas. So to be an immigration judge, you don't need to necessarily know everything or anything. You're supposed to learn it, get trained, and be assigned and do it. But that's a setting when you're facing. When you're going to immigration court, the person you're talking to, the person that you're trying to persuade, they might not know immigration law. They might have hundreds of thousands of cases that they're supposed to review, and now your life depends on their judgment. Right, not necessarily, just because of the practical nature of it. So when you are finally presenting your case in front of an immigration judge, don't assume that they know everything and they know all the remedies for it. You still have to prepare your case well. And this is where it gets tricky, because unlike a criminal court, you are not assigned a public defender. You don't have a right to an immigration representation, an attorney to represent you. And so do your best to prepare your case to explain why you can deserve to get a green card, why you deserve to get bail, why you deserve to stay in the United States. Now, if you hire an immigration lawyer to help you, obviously that will probably help your case, probably, right? So you really want to prepare those arguments well. And you can't assume the immigration judge knows everything. Now, even if an immigration judge approves your case, that doesn't mean later on they won't reverse it. And chances are the Attorney General is not going to go and reverse every single one of these cases. But if it's bad enough, a lot of times these immigration judges get fired. And so you have to understand that their job is on the line. They are not tenured. They are not necessarily purely with their North Star to justice, okay? Because it is a job. They got hired. They're supposed to be impartial. They're supposed to do things accordingly. And again, there's an adversary, right? The government is submitting proof that you deserve to be incarcerated, detained, sent abroad, visa canceled, Look, a lot of these immigration court hearings are not necessarily what you see on the news. A lot of times what you see on the news is there's these criminals, there's people who entered the U.S. illegally, there's people who overstay and they're, spies. Look, if you have a green card and you are overseas for a little bit too long, a little bit over a year, when you fly back into the country, the customs officer can take away your green card and say, no, I think you've abandoned it. Give it over to ICE, or they themselves give you a notice of intent to appear, and suddenly within 6 months, you have a court hearing. This has happened. I mean, I don't know how many cases we've seen this happen. And some of the craziest cases is just somebody who entered the U.S. and they left the U.S. only 3 months because they were in Canada for too long. Now, in the defense of the CBP officers, they say, well, we don't just look at this one entry, we look at the past 10 years. And look, this person clearly lives in Canada, comes here for a little bit, leaves. We gave them multiple warnings. They don't apply a re-entry permit. They don't have a clear proof of work in the U.S. Green card holders are not supposed to be using it like a visa, so we decide to confiscate green card and put them in immigration proceedings. And if you can prove to the immigration judge that you did not abandon your residency, then sure, but it's up to them, not up to us, right? So we've seen plenty of CBP officers exercise their discretion. You left the U.S. for over 180 days. Your past 10 years, you don't really file tax returns, you don't really do anything. So even though as a green card holder, they still take away the green card and put you through the immigration proceedings. The reason why I don't think immigration judges and immigration courts will ever become an Article 3 judge, as much as people want it, is because the immigration law is so part of the foreign policy, is so much part of the executive branch, that it is just almost impractical to do that. And it would just create so much chaos within the judicial system. You might say it is extremely unfair. I understand that. You might say they need better training. Totally get that. The appetite of the American public to be able to want to spend more money on hiring and vetting more immigration judges isn't that high, right? They just can't tolerate. Think about how much funding ICE is getting to expand their deportation machine. Immigration judges is very much part of that, but it's really expensive, the vetting process to go through this. And again, painting the picture, a lot of these immigration courts is just done on WebEx. It's just like a Zoom conference. You're not in a courtroom. There's no like official robes. It's just online, and you present your case. You might have 5 minutes, 10 minutes to present your argument. They might not know immigration law that well, but they know enough about your case. And if you don't make the right claims and the government makes a strong claim, then again, you lose your privileges and your rights, if you even had any. The part of the craziest thing about all of this, to me, oops, I touched the mic. Part of the craziest thing about this is that there's state courts with immaculate judges, super trained, intelligent, capable. They're deciding traffic tickets. You get $100 fine. You get a $50 fine. Okay, we'll waive your community service. Extremely capable people are appointed for life to adjudicate those matters. Yet the immigration court judge hired according to a political ideology, yet they are deciding life and death situation. You get deported because whatever they decide, then the next step, ICE completely takes over. Yes, deport, no deport. Stay the deport. You get a bond, you don't get a bond. Will you being deported cause extreme hardship on your spouse? If yes, then we might allow you to get a green card. If no, your suffering is not severe enough, maybe because you don't have the resources to prepare your case well enough, because you couldn't articulate it well, because the officer had a bad day, they couldn't hear, the Zoom was off for some reason. If they decide, oh, your hardship is not extreme enough, then you get deported, all within a very short amount of window. So very little resources to, I don't want to say fairly, to accurately really assess the situation by an officer, by an immigration judge who was appointed by the Attorney General, who was appointed by the President with a very political leaning. And if they don't adjudicate cases according to the political shift in this particular immigration, their job is on the line, that they can be fired. Is that true justice? Is justice supposed to be blind? And if justice is supposed to be blind, why tie it to a paycheck? These are strong arguments. I don't think, at least in this lifetime, I don't think immigration judges will ever become purely impartial like an Article 3 court judge, just because the nature of the political system and the way immigration law is set up in the United States. Immigration is very much part of the executive department, very much connected to foreign policy. So if you remove it and become judicial. Now, with that being said, it doesn't mean you can't appeal it, right? An immigration judge's decision can be appealed to the BIA, and then can be appealed to the federal courts, and then it can be appealed to the Supreme Court. But it is a long-winded path. It is expensive, it is long, and if you're detained for 2 to 3 years, maybe you don't want to go through that process, and you don't care about justice that much when you sacrifice 3-4 years of your life to be detained in a foreign country, right? So that is the nature and situation of our immigration system. ICE has wide latitude of authority to detain people, to check their status. They're understaffed, overworked, so they put a lot of people in detention center. Checking on whether or not somebody has status with USCIS is a long and arduous and expensive process in itself between ICE and USCIS. And then once they determine that they are going to go through immigration court, you are being adjudicated by an immigration judge who doesn't necessarily need to know immigration law. And they are also overwhelmed, understaffed. They don't necessarily have interns. They don't necessarily have staff. And they have only a few minutes to adjudicate each case. There's 3 million backlog. Their job is on the line. And it is more than, arguably very close now, more than 50% of immigration judges were all hired on by the current president, Donald Trump. So, is it fair? Is this what we should have? That's up to the public to decide. What my advice is anybody who's in this system, who is about to go see an immigration judge, who might see an immigration judge, do your best to understand immigration law so that you can present the best case you can, because these officers, even though they might be hired by the Attorney General, they're hired in this political climate, trust that they might still be good people and that they want to adjudicate things fairly. They are not just puppets, because we have seen, regardless of which administration is in place, we have seen officers and immigration judges approve cases that we didn't think could be approved, but they were able to put themselves on the line and adjudicate it because they see the hardship that America will suffer if this person was deported, that they will see that the U.S. citizen will suffer if this person was deported. So they exercise the 42A, they exercise the 42B. They don't want to waste taxpayer money. So if your case, you can argue how you being in the U.S. makes America more prosperous, makes America safer, and makes America stronger. Do your best, right? So understand the immigration law and advocate for yourself.
How long does an I-130 petition take to get approved when the spouse is in a different country?
It matters more whether or not that person is a green card holder or a U.S. citizen. U.S. citizen I-130 petitions typically take 1 year in our experience, sometimes a little bit less. Now, if you're in the country, if you file the 45 together, it's a field office adjudicating it, usually a little bit faster. If it's not in the field office because you're not a U.S. citizen, it's just a green card holder and you're overseas, then it could be a little bit slower at the service center. And sometimes it can take up to 2 years.
Can I be sponsored by a small restaurant?
Yeah, H-1B self-sponsor, that's a small restaurant, self-petition. A small restaurant can petition EB-2, EB-3, provided you prove that you just cannot find the person to hire. Small restaurants typically don't have a lot of budget, and it's really hard to find dishwashers. And so every restaurant that I know of probably could sponsor EB-3 because no American citizen around your vicinity wants a career in dishwashing, but it needs to be done, right? And robots could do it, but they might break too many, silverware. And so, yes, I've seen a lot of restaurants petition under EB-2, EB-3 to get green card. Not green card if it's a non-immigrant visa category, H-1B, self-petition. You make the prove that you are going to help this restaurant thrive and your position and what your education was.
If you have a misdemeanor, can you get a green card through your spouse?
So your question, the better way to rephrase that is a misdemeanor an inadmissibility to get a green card? Doesn't matter if it's through spouse, right? Anyone, right? But if you are going to get a green card, is a misdemeanor an inadmissibility, so you cannot get a green card because you got a misdemeanor during the adjustment of status or green card process? And the answer is most likely yes, you could still get the green card, and it is not an inadmissibility, but please prove and explain. It is not a crime of moral turpitude. It doesn't fall under one of the key qualifications. So based on that framework, use your ChatGPT, put your misdemeanor conviction up there and do a quick analysis. If it's good, you're probably good to go. If you want to double check, do a consultation with anybody who does this kind of stuff. And if you're good to go, just, prepare your case well and file and be confident.
I'm a U.S. citizen. I applied I-130 for my parents 11 months ago. How long does an approval typically take, or the process to get to the NVC stage?
So a year and a half-ish, and then NVC another 6 months-ish, and then the consulate interview might be 2-3 months-ish.
The U.S. citizen who applied recently lost their job. Can their spouse apply for their parents?
So your ability to petition your parents is you as a U.S. citizen. That's the most important thing. You losing your job just means you don't have the financial capability to continue to sponsor them, to sign the A64 form to say, hey, I guarantee that they will not become a indentured servitude in the United States, that they will not use food stamps, that they will not become a public charge in the United States. Don't worry, I got them. They're my parents. You lost your job. All right, so that's minus a couple points. But if you have enough assets, you have enough stocks, savings, you have a house, you have all these things that you can liquidate to sponsor your parents, well, then you put that as a collateral when you sign the A64 form. Assuming you don't have savings, you don't have stocks, you don't have enough, well, then you get a joint sponsor. So your spouse could do it, your other relatives could do it, So yeah, don't worry about too much. I-130, wait for that approval first, then do the NVC process. And then if you haven't found a job by then, again, use your assets or get a joint sponsor.
Can you do military parole in place for a parent that entered without inspection?
I believe we can. I've only done a few, and I'm kind of fuzzy on it. We did have one success story on that, and it is a parent who got it through their daughter who is in the military. But all the details of it is kind of fuzzy. But yes, military and parole is still a thing and can be done.
Is advanced parole still safe for DACA?
Yes. At least from what we have seen. I know there's all the crazy things that you've seen online, but we know CBP officers on a daily who are still approving them when they're coming back in. So apply for it. It'll take a couple months. Once you get the advanced parole, double check the news, double check what the process is, and actually fulfill the promise of what you got the advanced parole for, and then do your best to present your case at the customs office when you re-enter the U.S. To the best of my knowledge, from all the things that we've seen, I accompany clients down to Mexico to come back all the time, and their advanced paroles have still been approved. So we haven't seen widespread denials.
So they filed an I-130 for their spouse. Their spouse is in a different country right now. The spouse applied for a B1 visa to visit. They had a plane ticket to go back, but their spouse was denied their B1 visa because they didn't have enough proof that they would return to their home country. Do you think it's because of the pending I-130? What other supporting documents could we have provided? That's the first part.
The consulate has final say. You can't appeal the decision. You could keep on applying again and again, every month, go back in again, talk about, hey, we really want to go back to the U.S. The best way to get that B1, B2 visa while you have an I-130 pending is to prove, I just need to come to the U.S. this one time for this one key purpose, and I will not overstay. So how do you prove that? Right? Because to the consular officer, there's just such a high likelihood that you will just come to the U.S. and file adjustment, right? Because they've seen that done again and again. And today's story is actually about that. So stay till the end so you could see how a USCIS officer, the client flew in, filed the adjustment status, and the USCIS officer was going to deny the case and deport them, and how we had to overcome it. So, consulates don't like that. USCIS officers don't like that. So what can you do to prove I will definitely go back? So, provide that proof.
And just what are some key documents that you might provide?
Well, why do you need to come to the U.S.? What is your story, right? If you say, because I really like Disneyland, the officer will probably say, well, just wait a little longer, right? Once you get your green card, then go to Disneyland, right? If it's, I have a surgery, I'm a life-threatening surgery. I need to go get the surgery and then I'll come back. That's fine, right? Or if you have a really important job in your home country, there's no way you will quit it and you just want to go to the U.S. for this 1 week for this particular ceremony, sure, do that, right?
And then a follow-up, I want to travel to see her in December, but I have DUIs in the past. I have been pulled into secondary inspection. Do I still travel, and can I retain your office now for neutralization?
For naturalization or neutralization? Neutralize the CBP office,
or the threat maybe of getting pulled into secondary.
Oh, okay. That's a good one though. I'll use neutralize in the future, right? You naturalize in order to neutralize any threat that will be held against you. Let's set up a consultation. DUI, it could be a problem. It might not be a problem. You definitely want to have the record ready. Hopefully with the consultation, we'll be able to help you enough so you don't have to hire us for the full service. DUI as of now is not a deportable offense. You always go into secondary, so you can also use the DHS trip to try to clear that record. But, again, Congress is passing a law potentially that will make DUI a deportable offense, in which if you are unfortunate enough where you're abroad, you won't be able to get back in.
My wife has a green card and she will get her citizenship in 6 months. Should I do AOS now or should I wait?
Can you repeat?
Yeah, wife has green card. She's going to get her citizenship soon. Should I do adjustment of status now or should I wait until she has her citizenship?
Define soon. If it's within
6 months.
Okay, if it's within 6 months, probably just wait, because the hassle of upgrading is just it's not worth the 6 months. So, but if it's like, if some people tell me soon, meaning like 3 years, right? Like they got the green card, they just got it for 2 years, they're gonna file. Well, if it's 3 years or longer, file the I-130, at least get that approved, and so you can expedite the 45 later on.
Can a green card holder apply for a fiancé visa?
I don't believe so.
Can a case be denied without having an EAD and no interview?
I've seen many cases happen that way. For example, you file for an EAD only, EAD gets denied routinely without interviews. You file for adjustment and they don't even issue the EAD because you don't qualify for it, and they deny that. See that done routinely. They deny the case so fast that you don't even get an EAD and there's no interview. Seen that happen routinely. So is it possible? Yes, it happens all the time.
Can you do stay for self-deportation?
Can you do stay for self-deportation? I'm not quite sure what that means.
Any advice for a green card interview?
Yes. Know the underlying petition extremely well and be able to talk about your future. So if it's a marriage-based, know the I-130, know the family, know the bona fide marriage part. If it's a business, know your EB2, EB3, EB1 very thoroughly, and also be able to talk about the future, right? You're supposed to come to the U.S. How are you going to make the U.S. more prosperous, stronger, and safer? Being able to articulate that and explain that well is quite important.
How long after getting your fingerprints do you get your work visa? A T visa, if that's relevant.
I don't know, T visa. We don't really do a lot of those. Sorry.
I just got my receipt notice. Around when will I get my schedule for biometrics?
Usually 3 weeks to 4 weeks.
Okay, this is the stay for self-deportation. Can we ask for an extension for self-deportation?
You know, all of the clients that we've helped, they leave the U.S. and then they use a CBP app to talk about that they self-deported. So we haven't had any case where they self-deport before leaving and then actually going through that process. So because we've never done that, we don't know what the extension process is like. I expect, in the past, this isn't this whole self-deportation because that's really new, right? Self-deportation is completely new. In the past, it's called like voluntary departure with ICE. A lot of times, if they already are planning on deporting you and you request that, can you extend it a little bit? In the past, they can. So I can imagine that they extend that discretion over to the self-deportation. But again, I think it's up to the specific ICE officer who has your case.
Do you exploit our immigration policies?
Do you exploit the immigration policies? If you mean exploit by zealously advocating for our clients, that is the oath that we take to the judicial system. But there's tax law. Here's something good to think about. There are two types of tax law. There's two types of immigration law. One is for those who know, and one is for those who don't know. And they're both perfectly legal. So the rich uses their tax law to enrich themselves. Congress set it up. It's part of the laws that we have. And then there's immigration law. If you don't know, you say the wrong thing, you get deported. You say the right thing, you get a green card. All the craziness of that is our immigration law. There's CBP officers, there's USCIS officers, there's consular officers. It's a complete mess, but the laws are there. So if you know, the power of knowledge is just so important. And that's later on when I talk about this particular case, I'll show you exactly what I mean by that. And so exploiting the immigration system. I think it's just the unfortunate reality of the world that we live in, that knowledge is power.
If someone wants to enter the U.S., what's the best way to get citizenship or a student visa?
Those are two very different things, right? So normally you have to get a visa if you want to come in fast, and then you need to get a green card, and then you can become a citizen. And what is the best way? I mean, I think any immigration lawyer who's worth their 2 cents will say the best way is it depends on you. What is the best for you, right? If you have over $1 million and you can throw it away, potentially the EB-5 program might be the best for you. If you have a American U.S. citizen spouse, maybe that is the easiest for you, right? If you don't have either, but you are an extraordinary individual, maybe the EB-1A petition is right for you. Immigration law is actually quite broad, where it allows for a lot of things. You can help the cops catch bad guys and get a visa and get a green card, right? So there's just so many different things that the U.S. needs. You could be a dishwasher and get a green card, You could work in a farm and get a green card, right? And so understanding exactly what's the best option for you, I think that is the most important thing.
What's the timeline for VAWA now?
We don't really do a lot of VAWAs. And it depends on what kind of VAWA. There's so many different types. But if you're talking about in the marriage sense, VAWA, we see 751 VAWA cases take about 3 years.
Is it a good time to become a U.S. citizen because of the policies changing all the time?
I would say there's no better time. In the past 10 years, I don't know how many consultations and clients we've sat down and we've thoroughly discussed the pros and cons. Keep my green card or become a citizen. What's the difference? In the past, a lot of the end discussion is having a green card is practically the same as being a citizen, other than the benefit of voting and petitioning others. If you don't need to vote, you don't want to vote, you don't want to petition others, having a green card is almost better than being a citizen. That analysis has rapidly changed. Now, green card is almost becoming as insignificant as a visa. So easy to be revoked and so easily canceled. So having a citizenship is a much stronger protection.
My case for motion to terminate is pending. Can I still be picked up by ICE?
Depends on if you have an equitable relief that ICE recognizes, right? So let me unpack that for you. If you have DACA status, if you have a 485 pending as well, if you have other forms of equity that ICE recognizes as a valid permission to stay in the United States, they may not detain you and deport you. Now, there's so much to unpack there, because according to ICE, even having DACA status, they don't necessarily recognize that. Why? Because it's just an executive order, and they have a higher authority where if they think you are deportable with an offense that's deportable, they can still pick you up. Now, if your case is already being terminated, if you're going through the process already, if they already registered you, chances are they're not going to do that process again because you're already in the system, right? They're mostly going after people who are not in the system yet, but hopefully that gives you better context.
Is EB-2 still viable?
Thousands are being approved every day. Thousands are going to the consulate getting it. Thousands are getting it approved in the U.S. Is it viable? Yes, definitely.
I have a wrongful deposition order. Not mine. Immigration made a mistake. Someone else with the same name as me. Is this fixable?
Happens all the time. See this all the time. Again, it's not even the officer, by the way, who might have made this mistake. And when you talk about deposition, maybe you're talking about the travel records. A lot of times people travel with their passport name. It's the airlines that enter everything in to the I-9 system, and then they see it on the USCIS side, the CBP side. And so the American institution makes basically every other company and country around the world do their work for them, entering information. Now, CBP is supposed to have their own record and double check everything, but that record is only private to them. The world doesn't see it and have access to it. But yes, this happens all the time. It's a human error. You could get a
deportation order.
Oh, it's a deportation order that was mistaken. How?
They have the same name as someone else.
Oh, okay. So I guess you reopen the case and say, this is not me, this is why, and prove it, right? Yeah, that sucks.
Can an open container ticket be considered an immigration violation, like drinking in public?
What you want to do, because every county, every state has their own definition of what that crime is. Immigration law looks at federal law, and then based on your state convictions, then they adjudicate it. So you want to take the final minutes of your court conviction. You want to use AI to analyze it and say, is this a inadmissibility and deportable offense? Do I qualify for any exception? Do I qualify for the petty offense exception? Most likely, it is not an immigration offense, so you can still get a green card. But I don't want to say that immediately without obviously analyzing it. And again, every state is different, so I can't even analyze it. Even if you do come to me, I can't even analyze it if you're not in California, right? So I think that is the best way to go.
So the wrongful deportation order, they did a motion to reopen a year ago and haven't gotten an answer.
3 million case backlog. Immigration judges, things are slow, difficult, right? And so, the first question I think they will have is, why didn't you do it at the time of your hearing, right? The first removal defense. This isn't me, you served the wrong person, right? And why are you doing a motion to reopen it? Now, maybe you say, I've never gotten it, and then now I see it, and it's not me. Well, then, yeah, you want to go through that process to explain.
Can I fast track the process of a U visa if I join the military?
If you're doing like military parole, right, maybe. I don't think you can fast track the U visa, but again, we don't do enough of these to know. U visa by its very nature takes decades.
So this is about the mistaken deportation order. They found out when they were going to do their adjustment of status. Their I-130 is approved and they're under 245I.
So the 45 immigration officer is saying, sorry, we cannot continue to adjudicate this because there's a deportation order. And you're like, what? And they're like, yeah, look. And then you're like, that's not me, but it is you. So now they have to deny your case. So now you're reopening it. Got it. Yeah, do a crazy good job, prove that person is not you. And again, it happens all the time.
I got denied for asylum and I have to file an appeal. What other solutions can I use while waiting for their response? And if their appeal is denied, what should I do?
We don't do any asylum cases at the office. So I'm really not the best position to kind of advise on what to do after an asylum case gets denied. But based on what I know of general immigration law, immigration judges, if they deny a case, you could appeal it to a BIA, you can appeal it to a federal court, you could appeal it to the Supreme Court. So just keep on sticking with the fight, prepare your case well.
Should I get a lawyer before I start processing paperwork for citizenship?
Depends. If your case is easy, it's good. Do your best, and maybe all you need to do is somebody to second eye it. It could be a school teacher, it could be a nurse, it could be somebody who you trust, who's sophisticated, who've gone through the process, who knows the American system. All the instructions are there, all the forms are there. And if they and a couple other people go through the whole thing with you and it's good and it seems right and there's nothing that's wrong, have enough faith that the government will process the case accordingly and approve it, right? It's not like you're under any threat where if the case gets denied, you'll get deported. But if you have a criminal offense, they won't know. Well, it's probably a good idea to do at least a consultation, right?
Can U visas forgive entry without inspection?
U visas can forgive almost anything and everything. So take a look at it. It's crazy powerful. Things that no other visa, no other green card methods can forgive, a U visa could forgive. So yeah, check it out.
My first F1 determination letter has been expired for 6 months, and I still need a new one.
And I'm assuming you're talking about your I-20. So
they say FIS. I don't know if that's an acronym.
Not quite sure. But if it's an I-20, you come into the school and you're supposed to study, but your status is duration of status, so you can continue to study on anything else. So even if the I-20 expired, you can continue study somewhere else, or you're on OPT, so it continues.
How much would it be? Can you sum up the U visa answer?
Yes, it can forgive.
How much would it be for you guys to help me with my SB1 visa?
I'm pretty sure we're not doing any SB1 visas at the firm at the moment. The success rate is like less than 1%. We highly discourage it. So the last one we did, I think, was like last year. So we're not doing any SB1s because the success rate is too low. Usually you have a much better shot at directly flying to the US, directly talking to a CB officer, or directly dealing with an immigration judge like we're talking about. With a consulate SB1, almost always denial. And the few cases that we did get approved, the clients regretted it, right? There's like, why did I go through this process? It's so long, so tedious, so tiring. Why didn't I just fly to the US and do it? And they're like, we told you so, but you still chose to do it the SB1,
Okay, so the F1, it's the I-360 F1 determination letter is already expired, and then they're going to get a new one.
Not sure what that is. Yeah.
Do you think someone will get out of custody if they've been here for 15 years, pay taxes, etc., or even get a bond?
I think the question is, if somebody has been taken by ICE, will they be able to get a bond or be able to get a green card? Provided that they had lived here 15 years, they pay taxes, they're, important to the United States. So basically you're saying, I qualify for cancellation and removal 42B, right? You can look that up. If I have a strong case, at least on the face of it, will I be able to get a bond to be able to not be in detention center for like years? And would I succeed on the claims and be able to get a green card through the immigration judge? In the past, I would say yes to both of them, right? You're telling me you qualify, everything is good. So yes, ICE will probably let you out on bond and you'll probably get a green card. But that's, like a tautology. You're saying your case is good and I'm saying that you'll get approved. But in this day and age, under the mandatory detention, you might not be able to get a bond. And even if you do have a good case, immigration judges are very reluctant to approve 42B because they will be under high scrutiny by the Attorney General.
Apparently he's been there for almost 2 weeks already.
And that is actually quite short because we've seen people who have been in detention for 6 months or longer, even as a green card holder.
With ICE's pick up first, ask questions later approach, is it safe to go into an immigration office?
You're talking about like USCIS, CBP, or ICE. Because generally speaking, with USCIS and CBP, they don't really refer cases to ICE to be picked up unless it is like really bad and like there's clear no signs of relief, right? So for example, you're 45 denied based on misrepresentation fraud. Like for example, the client I'm talking about today, potentially if at the hearing they get denied, they might be immediately picked up by ICE. But if it's like a biometrics appointment, typically speaking, not like a ICE biometrics, I-131 biometrics, 765 biometrics, 526, 829 biometrics, I don't think you're at risk of being detained by ICE.
I had a first DUI and I'm a green card holder. How bad is that?
Now, bad, but not that bad. If Congress passes the law, pretty bad.
Is being abroad for 3.5 years too long for a minor to return to try CBP entry? This is a follow-up from the SB1.
Yeah. We have done a lot of cases like this. I encourage you to check on our YouTube channel. We have probably 90 plus videos of different success stories. This particular case, we've helped many kids who have been overseas 5 years, 6 years, maybe even 7 years, 8 years, come back. Some of them even with an SB1 denial, right, to talk to the officer. So definitely possible, but you really want to prepare your case. A lot of these cases, we spend like half a year preparing, right? All the transcripts, the fluency, what are they going to study in the US afterwards? The apology letter from the parents even, So it's possible. So again, summarizing it, SB1 denial, almost 99% denial, probably 100% if it's 3 years. CBP entry, much higher.
What if you're married and your wife isn't ready to file yet?
File for what?
Green card, probably.
Okay, then, talk it out, see a therapist.
You basically just have to wait.
Yeah. I mean, lots of people get married and they live in two different, countries. So let's say you're a U.S. citizen. You got married to somebody who's not have any status. Yeah, you guys could leave the country and live abroad for a couple of years. And then once you're ready, then petition and come back, right? A lot of people do that. A lot of expats do that. So it's not like, the government's not forcing you. You married a foreigner, you have to get them status immediately. Some people choose not to. In the past, affects it a little bit. You want to prepare a good case, right? We've helped so many people with DUIs get citizenships. I don't know, I can't even count, right? Probably in the hundreds now. If going forward, it's getting harder and harder because the totality circumstance analysis for discretion for USCIS officers, plus a new law that might be coming out that make you a deportable offense, it's going to be much more serious.
What are the rates of winning a 42B?
Low and getting lower.
Is filing for VAWA okay if I have sufficient evidence?
Yeah. The million-dollar question is what is necessary and what is sufficient, right? So you might think it's sufficient, officer might not think it's sufficient, so So do your best to prepare well and then get second opinions from other people who are smart, capable, that you like, that give you feedback so you can prepare and submit.
Okay, we can't give advice on how to commit a crime. So is getting denied for global entry affecting my naturalization?
Not necessarily. Yeah. Global entry versus naturalization, completely different tracks. Doesn't have to be connected. And there's all sorts of reasons why your global entry could have been denied. But they also could have the same cause, right? So if you have a felony, global entry will be denied. And that felony can cause N-400 to be denied and cause you to be deported, right? So not a major cause of concern, but obviously you should know the underlying reason why and try to find out. And if you don't, you should find out because, what if CBP says, hey, you're actually on a list in Interpol? Well, that's not me, wrong person. Well, that might cause your N-400 to be denied.
Okay, and the last question we'll take, who makes the decision of an immigration bond?
Initially, ICE, right? Because ICE has their own bond. Initially, ICE, but supposedly immigration judge, ultimately.
Okay, and our last question. 2 days ago, I got work card approval. How long will it take to actually get that work card in the mail?
I would say less than a month, 3 weeks, 2 weeks. Congratulations. You can see how immigration has completely changed with this case. Many people say you fly to the US, you get married to a US citizen, and you get a green card. Easy peasy, simple, nothing to worry about. With this case, you could clearly see it is a US citizen marriage. They flew in. Their one little answer that arguably was incorrect with the CBP officer was recorded, and USCIS now issues a notice of intent to deny their green card application. Never mind the marriage is real, never mind it's a US citizen, never mind all that. There is a fraud conviction now on this lady because of one small thing, whether she said it or not, but CBP officer typed it into the system. Let me go through this case with you and what the USCIS officer now required the family to do, right? So this year in May 2025, the clients show up to our office showing us this notice of intent to deny. The clients flew in 2024. Subsequently, they got married, filed a 485 application. So this is exactly what happened, right? This is the notice of intent to deny. And by the way, if the 45 is denied, the client needs to leave. They cannot do anything else. And if they don't leave, they can pick up ICE, they put in deportation proceedings, right? So in 2023, they got a tourist visa. In 2023, they flew into the US. In 2023, they were married. They got a K visa. There's an I-130 that was filed. And the whole reason why there was a fraud claim was because when they were flying in, the lady showed a return ticket. And obviously, the client did not use the return ticket. And then they filed for the I-130 and the 45. And to the USCIS officer, by you showing a return ticket to a customs officer, that was a material misrepresentation. You had the intent to use this return ticket to deceive an immigration officer, showing that you are planning on returning when you in fact did not have that intent. And so when you entered, so you used that, you misrepresented yourself in your situation. So now you have a fraud claim. And that is an inadmissibility deportable offense. Doesn't matter if you are married to a U.S. citizen, even if a U.S. citizen can help you waive potential unlawful presence, assuming you entered legally, but a U.S. citizen cannot automatically waive any misrepresentation. So now USCIS officers, when they're doing these interviews, they look at how you got the tourist visa, they look through the DS-160 application, they're supposed to check the CBP records, what did you say, and look through anything. And if they find one thing, and in this instance, it was, I have a return ticket. Because you showed you have a return ticket, we deem you to have misrepresented by the actions that you took later on. And so therefore, you need to submit a waiver. What happens next? They show up at our office. We had 1 month, because notice of intent to deny, you only have 1 month. Request for evidence, sometimes you get 3 months. Notice of intent, NOID, you only have 1 month to prepare your explanation and present a waiver. What is a waiver? You need to present that without you, the U.S. citizen will suffer extreme hardship in the United States. And if you prove that, then the officer waives your wrongdoing, waives the misrepresentation, and allows you to get a green card. Essentially saying, by removing you, we are harming our own citizens, so we're not going to do that. But you have to prove extreme hardship that warrants a forgiveness of this misrepresentation. It is tough, it is hard, and time is short. A lot of times, 601 waiver applications, we take half a year, we take a year to prepare. But in this case, we had only 1 month. Is it a severe misrepresentation? Is it even a misrepresentation, right? I mean, that's the first thing I always ask. What are the elements of misrepresentation? You showed a return ticket. Does that automatically mean you were deceiving an officer? People change their minds. It's okay to change your mind. It's perfectly legal, right? I've flown somewhere before and suddenly I don't want to come back so fast. I want to extend my stay a little bit. That happens all the time. Is that a misrepresentation? To the officer, it was sufficient cause to make this claim. And so now, let me go through the waiver application, right? We talked about the law. We talked about the extreme medical hardship on the U.S. citizen spouse. We talked about the extreme emotional hardship on the U.S. citizen spouse. We talked about the extreme financial and career hardship on the U.S. citizen spouse. We talked about the valuable asset to the U.S. and the good moral character, and the final determination. We submitted 19 pages in attorney brief. We submitted over 20, let me look, 28. We submitted over 29 documents, over 500 pages, to document why this person deserves to be in the United States and why they deserve this waiver. Normally, again, we have a long time to do it. In this case, it's very short. U.S. citizen, their entire family was freaking out, obviously, because they thought it was simple, right? It's supposed to be, you got a tourist visa, you fly to the U.S., You get married to a U.S. citizen, you get a green card. It should be simple. But one little thing caused the officer to scrutinize it. And if not done well and not done timely, the entire case will be done, and now she will be deportable. And guess what? If she does get deported, probably end up divorced, or it's a long distance marriage for potentially 5 years or longer. It was a very difficult case. I did not think it would necessarily get approved. We did not have super high confidence. We just did our best to make all the arguments that we know, because we do a lot of 601, but we just had to borrow all the tools and make a quick argument here and now. We borrow from the non-immigrant visa argumentation, where we do a weighted balance. What was the offense that was committed that was so wrong that you desire that the United States government wants to punish this U.S. citizen? What was it so wrong? What was it so bad? They presented an airline ticket. Was it really fraud? We explained that, and all the positive effects of this lady in this marriage with this U.S. citizen in the United States. So just this week, the case was approved. The green card is in the mail. Happy to share that story with all of you. The officer, in the past, we would almost never see something like this happen. It is extremely rare where something like this happens, right? This person came from a good family, a good country. Officers typically don't challenge these and don't require waiver applications. I don't know if we did an overkill by submitting like 19 pages and 20. Could we have submitted a 4-page attorney brief? Could we have just submitted a checklist of documents and get approved? Maybe, maybe not. We don't know what the officer's mind was, right? But we knew we have 1 month, and we knew that if we don't do it well, the consequences are high. And so we just had to prepare as much as possible, like it's a normal waiver case, to win this for the family. I just want to stop and kind of share this entire situation with this administration. It's part of why President Trump was elected. He's strict on ICE, he's strict with USCIS, and he's strict with the immigration judges. And now your case needs to be completely above board, squeaky clean. And if you run into any problem, sometimes you might only have a month to prepare to respond. And again, you're convincing an officer on the other side. I believe there are good officers, and I believe there are good immigration judges. I even believe there are good CBP officers and ICE agents, because we've seen them do their job in the past. But in this climate, they are under an ultimatum, a mission directive to safeguard the United States from any crime, and they're supposed to scrutinize cases with the highest strictness. That's just the law of the land right now. So my encouragement to everyone is, whatever case you're filing, understand it in and out, completely have a mastery over it. With ChatGPT, with AI, you should be able to understand it better than anybody who have ever done it in your life, in your past, all your friends and family, and just prepare the case better than anybody who's ever done it, because it is your one chance, one opportunity to get your visa and get your green card and get your citizenship. Hopefully that helps, right? If you have any questions, feel free to reach out. Thank you for watching. Take care. Bye-bye.